Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's discussion. On this week's discussion, I want to talk to you about depositions. Now, I know sometimes when I say the word depositions to a group of qualified medical evaluators, I can feel the shudder of anxiety that flows through the group. And I want to ask you, do you ever feel anxious? Do you ever feel nervous? Do you ever get even actually upset, visibly, emotionally upset in the days and hours preceding deposition? Well, I want you to know that many qualified medical evaluators feel this way, and I used to feel this way myself. I can recall being extremely anxious, nervous, and insecure in the days leading up to deposition, and this feeling only intensified as the deposition approached, to the point where upon the day of the actual deposition, I would find myself to be in actually rough shape. I would find myself to be breathing fast and hyperventilating and sweating and anxious and extremely uncertain as to how I would perform in deposition. And then at the deposition itself, it seemed that the room was always too small. The parties were too close, the thermostat was set too high, there was too little air circulation in the room, and there was too much intensive eyeballs focus, all eyeballs focused on me at deposition. And I can tell you that it was very, very disconcerting, and I would have done almost anything to avoid having to go to deposition. Well, the great breakthrough for me came when I realized what is actually the purpose of deposition, which created the breakthrough for me, the breakthrough in comfort, the breakthrough in ease, and the breakthrough in enjoyment, and the breakthrough to the point where I actually started looking forward to deposition. Now, you know, it's very, very interesting. We as qualified medical evaluators are very confident and knowledgeable about what it is that the work that we do. But we have very little knowledge, very little understanding, very little insight into the roles, duties, procedures, and responsibilities of the other parties involved in the system. So while I, as a qualified medical evaluator, have a very good understanding of what it is that I do within the system, I have very little understanding as to what, for example, the disability evaluation raters do in the course of their daily responsibilities within the same system. I have very little understanding as to what are the duties, roles, and obligations and responsibilities of the defense attorneys. As the defense attorneys go about their daily business, attending hearings and attending trials down at the Workers' Compensation Appeals Board, I have very little understanding as to their needs, roles, and duties. And they, even though they think they do, they have very little understanding of what goes on in my world in the face-to-face evaluation. And so we have all these parties working together in the same system, with all of the parties having very little understanding as to what the other party's needs, wants, desires, and responsibilities are. So we come to deposition, and many times the parties present to us questions in the deposition that come to us from their perspective of their needs, their wants, their responsibilities, their obligations, their duties within the system. And so, lacking understanding of the other parties, we sometimes take these questions as curveballs and as surprises, when in actuality, these questions come to us, even though we can't anticipate these questions come to us to give us a tremendous learning opportunity as to the roles, needs, and duties of the other parties and players in the system. So in actuality, a deposition is a tremendous opportunity for you to learn and expand your full potential as a qualified medical evaluator in a way that you can achieve through no other avenue except through attending many, many, many depositions. So I have a fascinating discussion for you today, one that I'm sure is going to help you in your very next deposition, and it's going to help you to learn to understand what it is that the parties need from us as qualified medical evaluators so that they can continue about their job in resolving disputed cases in the workers' compensation system. So I want to share with you some ideas about what it is that the parties actually do need from us, and what are the most common reasons that attorneys have for calling us to deposition. So I want you to imagine that you receive a phone call for a deposition, and let's pick up from that point in time and take a look at what are the most common reasons and the most common questions that the attorneys are going to ask you at deposition so that they can simply fulfill their job responsibilities. Okay, so with that as our introduction, let's begin today's discussion, and let's imagine the point in time when your phone rings with one or more of the parties requesting 4 or 5 dates from you so that they can bring you to deposition. Okay, so let's begin. So imagine this. Imagine your phone rings and you answer the phone, and on the other end of the phone is a legal secretary for the law firm associated with one of your recent claimants or examinees for industrial injury, for whom you provided a QME evaluation. And she wants to know what 5 dates you have in the next 8 weeks available for deposition. And so as you get out your calendar and you start looking over available dates for deposition, you're thinking to yourself, why in the world would they be calling me for deposition? Why are they calling me? Okay, so this is the applicant attorney, or this is the defense attorney. Why are they calling me for deposition? And so you do as you're asked, and you provide 5 dates for deposition, and the legal secretary informs you that she'll contact the other party, and she'll get back to you with a confirmation as to the day, date, and time. And after you hang up the phone, you pull open your computer and you open up the QME evaluation of this particular examinee. And as you go through the QME evaluation, you're wondering to yourself, why are they calling me for deposition? What do they want to know? What didn't I address? Where was I wrong? Right? You always ask yourself that, right? What did I do wrong? Where did I opine without support? Where did I stick my neck out? What did I say that wasn't true? What did I conclude for which there was no support in the medical records? How did I contradict myself? How do my opinions and conclusions contradict the opinions and conclusions of others? And 1,000 questions go through your mind wondering, why are they calling me to deposition? Well, as the next couple of days and weeks go by, you still wonder this to yourself. And as the deposition approaches, you start to have a new set of wonders and a new set of worries, wondering, I wonder what they're going to ask me. I wonder what the issues are, and I wonder what they're going to ask me. And how will I answer correctly? And how will I answer this? And how will I answer that? And what if they ask me this? And you might even call up a colleague of yours and attempt to troubleshoot some of the issues that the colleague finds in your report that you may have overlooked when you wrote the report yourself. And so there's this whole confounding process and this whole anxiety that confronts us as the qualified medical evaluator about upcoming depositions. And you wonder to yourself, well, where will the deposition be held? And what will the environment be like? And who's coming? Is it a male applicant attorney and a female defense attorney, or vice versa? And who's going to be there? Where will it be? And what will the environment be like? Will the room be comfortable? Will it be spacious, or will we be close together? And there's this whole anxiety that qualified medical evaluators have about attending deposition. Well, what I want to share with you today is designed to give you some relief and some comfort about approaching your very next deposition, because the number of issues for which you're called to deposition, number one, the number of issues for which the parties can call you to deposition, and number two, the numbers of questions that the parties can confront you with at deposition are finite, are limited. It's not an infinite number of issues. It's a very finite number of issues. And if you can understand those issues, you can feel more comfortable preparing for those issues, and you can feel more comfortable going to the deposition. Similarly, the number of questions about those issues that the parties can spring on you in the hot, confined, no air circulating room of the deposition room is very finite. And so if you can get a handle on those, you can perform beautifully, and you can feel good about yourself knowing that you presented yourself professionally and as a well-qualified medical evaluator, and you can feel good about yourself, and you can actually look forward to depositions as the educational and profitable experience that they actually are. So let's begin today's session talking about the most common reasons that depositions are called for, and this has to do with the most common reasons that the applicant attorney would call for a deposition and the most common reasons that the defense attorney would call for deposition. And then within those reasons, what are the most common questions that you're going to be faced with related to each of those issues? Okay, so let's talk about the most common reasons that the applicant or defense attorney would call you for deposition. Okay, so before we get into that, let's first talk about some of the labor codes and codes of regulation that deal with the deposition process. So the first one I want to share with you comes from CCR Chapter 4.5, Subchapter 2. It tells us that the Workers' Compensation Appeals Board favors cross-examination of medical witnesses like us, we're medical witnesses, by way of deposition. Deposition, in other words, you're not going to be called to come down to a courtroom atmosphere. Long before any of that takes place, the parties cross-examine you by way of, number one, supplemental report, or number two, by way of deposition. So you're going to be called to deposition throughout your career, and reasonable costs in connection with such deposition shall be allowed under Labor Code Section 4621. And let's just talk about those fees here for just a minute. Now, the fees for medical legal testimony, also known as depositions, have recently increased in April 2021 with the passage of the new medical legal fee schedule. And I was at the medical legal fee schedule committee meetings, and I can tell you exactly how the discussion regarding how we as qualified medical evaluators should be reimbursed for depositions went down. I can tell you exactly how it went down. And how it went down was that the group, which is about approximately 30 to 35 stakeholders situated circumferentially around this large boardroom down at the Division of Workers' Compensation in Oakland, the group decided and agreed that most qualified medical evaluators consider depositions to be a high-stress environment. And so the group agreed that qualified medical evaluators as a group deserved some additional, what they referred to as hazard pay, hazard pay for putting up with the stress associated with depositions. So we recently received an increase in fees from $250 to $455, almost a doubling of our fee for the hazardous high-stakes environment associated with depositions. And our new fees are described under new Medical Legal Billing Code ML204, and I'll just read that with you now. It tells us that the physician shall be reimbursed at the rate of RV7, or his or usual and customary fee, whichever is less. So if you like to charge more for your depositions, your fees are capped by the ML204 code at RV7. You can certainly bill less, but you would be leaving money on the table compared to what's allowed under this billing code. Rounded to the nearest quarter hour, so 7 minutes gets rounded up to the next 15-minute quarter hour. spent by the physician. The physician shall be entitled to fees for all itemized, reasonable, and necessary time spent related to the testimony, including reasonable preparation and travel time. So your three basic fees associated with deposition are going to be preparation time, travel time to the deposition, and travel time from the deposition, and then also your time spent in actuality at the deposition. So when you're at deposition, keep an accurate and agreed upon, keep an accurate accounting of the start and stop time of the deposition, and get an agreement from the parties, from all the parties, as to the accuracy of the stop time. At the end of the deposition, you may say to all the parties, okay, so can we agree that our stop time today is 10:10 a.m.? And all the parties will agree. And you can use that as your stop time that you document for your billing purposes. Tells us that the physician shall be paid a minimum of 2 hours. So at $455 per hour times 2 is $910 for the hazardous deposition of 1 hour of deposition. So the minimum of 2 hours consists of 1 hour of preparation time and 1 hour of face-to-face time at the deposition. If a deposition is canceled fewer than 8 calendar days before the scheduled deposition date, the physician shall be paid a minimum of 1 hour for the scheduled deposition. And now this is a more generous, meaning generous for us as qualified medical evaluators, this is a more generous cancellation fee even than that provided for our regular QME evaluations, which has a 6-day cancellation deadline. Depositions have a 8-day cancellation deadline. So this is a very generous policy that considers the stress and anxiety that qualified medical evaluators experience apparently at deposition. So if you can learn to enjoy depositions, you can be paid handsomely for your deposition. You could be paid minimum of 2 hours and even beyond 2 hours should the actual face-to-face deposition take longer than 1 hour. And then you also get reimbursed at the rate of $455 for your travel time to and from deposition. So you may consider this as a very attractive incentive to get good and to get comfortable at depositions. So in order to help you become more comfortable at depositions, let's talk about some of the most common reasons that both defense and applicant attorneys have for calling you to such a deposition. So let's talk about those reasons, and let me set the stage for you for this discussion. One time I was giving deposition testimony myself, and at the deposition were, of course, 2 attorneys, an applicant attorney and a defense attorney. And the applicant attorney I had some prior cases with, and I had a casual relationship with the applicant attorney, meaning I had seen the applicant attorney around town, at the post office, the grocery store, and acknowledged the applicant attorney at these locations, but didn't have any relationship beyond that, beyond the couple of cases that we had in mutual, that we had mutually. And so this was my first chance to, speak to the applicant attorney and get his take on depositions. And so we went through the deposition, and it seemed to me to be a nonsensical deposition. There wasn't really any issues of any great importance handled at the deposition. And after the deposition broke up and the defense attorney left and the court reporter left, and the applicant attorney and I were sitting there together in this room together, and I asked the applicant attorney, I asked him, what about this deposition? This was a silly deposition, seemed like a complete waste of time. And I asked for him to provide me a list of the top 10 reasons that a defense attorney would call for a deposition and the top 10 reasons that an applicant attorney would call for a deposition, and he provided me with such a list. Now the list I'm going to share with you in today's discussion comes from the perspective of the applicant attorney. Now the list might be different if I ask the same question of a defense attorney. But what I'm going to present to you today is the list of reasons from the perspective of the applicant attorney. And I'm just going to share with you just a small handful of reasons as to why the defense attorneys and as to why the applicant attorneys would call for your deposition. So this applicant attorney provided me the list of the defense reasons, and he told me number one, top reason. This was the number one reason, and that is to generate more billable work hours for the defense law firm. Now remember, this comes from the perspective of the applicant attorney who cannot bill for attending deposition. So applicant attorneys and defense attorneys have a different perspective on depositions in that one gets to bill, whereas the other one does not get to bill. So you need to be aware of this. You need to ask yourself, is this simply the defense attorney, if they are the one that are calling you to deposition, are they simply trying to generate more billable hours? Because they certainly will be generating billable hours. Reason number two is to harass the applicant attorney, and this is coming from the applicant attorney himself, hoping to consume so much of the applicant attorney's time to make the applicant attorney more likely to agree to a less than optimal settlement. In other words, as the time starts to accumulate on the applicant attorney sees his hourly wage and his profitability from the case dwindling and diminishing as time accumulates. And this is the great use of time. The defense attorney twists the applicant attorney's elbow by consuming so much of the time of the applicant attorney that any profit that there was in the case simply dissipates down to zero. The third reason that the applicant attorney shared with me that the defense attorney would use to call for you as a qualified medical evaluator to call for your deposition is to prolong the litigation to try to starve out the applicant. And I see this one happening all the time. So the defense attorney wields tremendous power in the use of their time in starving out both the applicant attorney and also in starving out the applicant. Okay? Reason number four is to prevent the case from going to trial. In other words, blocking the case from going to trial early. In other words, creating a reason that the case is not yet ready for trial by claiming that we have not even yet deposed the doctor, and then repeatedly rescheduling the QME deposition as exactly as what occurred in the case I just shared with you. Again, exhausting weeks and months of time in an effort to twist the elbow and gain a strategic advantage over the applicant and the applicant attorney. And then reason number five, and this is not a complete list, I'm just sharing with you a few reasons from the list, is to actually discuss medical legal issues. And when the applicant attorney gave me his list of the top 10 reasons, this was actually reason number 10 cited by the applicant attorney, was to actually discuss the issues related to the case. Now, I don't know if the applicant attorney was just being sarcastic about that, but you may put this to the test yourself in your very next deposition and see how much wheel spinning and time wasting goes on before actually even getting into the issues involved with the particular case. Okay? So there's a small list of reasons for the defense attorney to call for deposition. What about the applicant attorney? So according to the applicant attorney, some of the reasons for calling for the doctor's deposition are as follows. And here in this section, we're going to also handle some of the questions that the applicant attorney might pose to you as the doctor in relation to some of these issues. So according to the applicant attorney, they don't have the same motives for calling for deposition as does the defense attorney. They don't have any of the financial incentive drivers as do the defense attorney. So the applicant attorneys are going to be more concerned about the issues of the case. So for example, in the case of an adverse opinion by the qualified medical evaluator, they're hoping that the QME cannot schedule the deposition within 120 days as required by law in order to discharge and get rid of an unfavorable QME report. So for you as a qualified medical evaluator, if you want to retain the case and stay on the case, make sure to schedule your deposition or the deposition within 120 days of the request. And this should not be difficult for you to do at all. But there's a small percentage and a small population of qualified medical evaluators who are so busy that they cannot schedule within 120 days. And this is one avenue wherein the applicant attorney can get rid of the QME report and start over in hopes of getting a more favorable report for their client. Then issues turn to disputed issues related to the case and the claim. So for example, disputes about the permanent impairment rating and the application of the Alvarez and Guzman line of cases. And in every single case wherein you provide a permanent impairment rating, you can expect the applicant attorney to challenge you on the permanent impairment rating and to attempt to persuade you to provide a higher permanent impairment rating, both under the strict application of the AMA guides and then also through the use of analogies and alternative impairment ratings under Alvarez and Guzman. And they will present to you all manner of arguments in an attempt to obtain for their client what they consider to be the most accurate description of the permanent impairment rating. So always expect the applicant attorney to squeeze you and squeeze you and squeeze you for a higher and higher and higher permanent impairment rating because it's their job. Okay, so that is money issue driver number one, is the permanent impairment rating. Well, second money issue driver of the need for an applicant attorney to call you for deposition has to do with apportionment. And again, there are many possibilities to discuss here, and we'll just discuss one of them. And it pays for you to remember that with apportionment, apportionment deals with nickels and dimes, whereas permanent impairment deals with big dollars. So by the time you've rendered your big dollar permanent impairment rating, the apportionment determination determines how those dollars are divvied up and who has to pay what percentage of those dollars. And a certain percentage of those dollars are to be paid by the claims payer, and the other percentage is to be absorbed or assumed by the injured worker themselves. And the applicant attorney and the defense attorney have opposite and competing motives here. It's the burden of the applicant attorney to prove the percentage of permanent impairment due to the industrial injury, which is compensable for their client, always seeking to maximize the percentage of permanent impairment due to the industrial injury, whereas the defense attorney has the burden of proving the percentage of permanent impairment due to other factors other than the industrial injury, which are non-compensable and which are to be assumed by the injured worker themselves. And the defense attorney is going to continually strive, and twist your elbow to increase the percentage of permanent impairment due to other factors. The applicant attorney is going to strive to increase the percentage of impairment due to the industrial injury. The defense attorney is going to strive to increase the percentage of permanent impairment due to other factors. And let's talk about how an applicant attorney might approach you with some questions in a case wherein you provided for some apportionment of the permanent impairment to other factors in the form of degenerative changes found on x-rays. Okay, so this is a very common scenario. Many qualified medical evaluators, in providing their apportionment approximate percentages, will provide a certain percentage of the permanent impairment to be due to other factors, non-compensable other factors, such as degenerative changes of the spine, of the shoulder, of the knee, of the hip, etc. And let's just see some questions, and let's see if we can anticipate some of the questions that the applicant attorney might ask you in an attempt to discredit your apportionment determination and in an effort to increase the compensable permanent impairment due to the industrial injury. Okay, so let's explore some of those lines of questionings here. Okay, so imagine this. Imagine you have an examinee and you've provided a permanent impairment rating to describe the examinee's condition. And let's just say your apportionment percentages were 75% of the permanent impairment due to the industrial injury and 25% due to other factors. Well, the applicant attorney is going to be motivated to get the apportionment percentage more closer to 100% due to the industrial injury and 0% due to other factors. And the applicant attorney is going to be more and more of a dog on a bone the more ground he or she has to gain towards the 100%. So, for example, if you provide an apportionment determination of 50-50, the applicant attorney is going to be extremely motivated, more motivated than they will be if you provide for percentages, for example, 90-10. And in this example, let's say you provide apportionment approximate percentages of 75% due to the industrial injury and 25% due to other factors. What line of questioning can you anticipate? Well, how about some lines of questioning that have to do with your understanding of the laws that govern apportionment that are currently in effect in the state of California? How about this question? Doctor, what is your understanding of Labor Code 4663? And then after you provide your answer, how does Labor Code 4663 apply in this case? And the philosophy behind this question has to do with your understanding of correct legal principles. In the Escobedo case, Escobedo told us that in order for your apportionment determination to qualify as substantial medical evidence, it must be based on correct legal principles. The opposite of correct legal principles is incorrect theories and incorrect understanding and incorrect interpretations of these laws. And so the applicant attorney is going to first test you to find out if you actually have a proper understanding and a correct understanding of the correct legal principles governing the apportionment approximate percentages. Well, if he's satisfied that you have some understanding of correct legal principles, the next reasonable question that you could anticipate would be something similar to the following. Doctor, with regards to degenerative changes, or whatever it is that you're apportioning to, such as obesity, such as diabetes, such as asymptomatic pre-existing conditions, such as retroactive prophylactic work restrictions, whatever it is that you're apportioning to, he's going to chip away at, right? He's going to ask you, what facts do you rely on to conclude that this condition, whether it be diabetes, obesity, whatever, is causing impairment at the time that you evaluated the examinee? So by impairment, we mean functional loss, loss of use, or limitations with activities of daily living. So remember that with the apportionment determination, you're providing the parties with your opinion as to the multiple factors that are contributing to the examinee's impairment on the day that you evaluated the examinee. So if you apportion to degenerative changes or pre-existing conditions or whatever, you have to have some facts to support your opinion that that condition is contributing to the impairment. You have to have some facts, and he's going to ask you to show your cards. He's going to ask you to expose your facts, to show your hand, and your facts better be good, and your facts better be relevant to the case. See, there's a difference between facts and relevant facts, okay? And your facts have to be relevant to the determination in question here at the deposition. Okay? What other questions can you anticipate if you decide to apportion to any other factors? So before we get into those other questions that you can expect related to medical legal issues such as your apportionment, approximate percentages, and all of the other opinions and conclusions, and before the questioning at deposition gets too deep and too stressful, let's just talk about how to handle issues when you feel that one or more of the parties are becoming aggressive toward you, or that they may be badgering you in an effort to get you to say something that you may regret later or that you may not be comfortable in saying. And this has to do with California Code of Civil Procedure. And this is a procedure that protects you as the deponent and gives you as the deponent many rights during the deposition. And this is something that you will rarely have to rely upon, but it's important for you to understand, and it's important for you to take comfort in knowing what are your rights for those times when you feel that you're being mistreated or treated improperly during deposition. And this particular Code of Civil Procedure will help you, and it relates to your rights as a deponent. So let's read this together. It says that before, during, and this will mostly relate to us during deposition, but before, during, or after a deposition, any party or deponent, any deponent, and that's what you as the qualified medical evaluator are at deposition, you're the deponent. It says before a deposition, the deponent or any other affected natural person or organization may promptly move for a protective order. So you can ask during a deposition if you feel like you're being mistreated. You can ask for a protective order, and the protective order protects you. And it gives us some guidance about what constitutes good cause in moving for a protective order. It tells us that the court, for a good cause, may make any order that justice requires to protect any deponent from unwarranted annoyance, embarrassment, or oppression, or undue burden and expense. The protective order may include, but is not limited to, one or more of the following directions. And we'll talk about those directions in a minute, but let's just take a look at this particular passage from this Civil Code of Procedure. It says that no party has the right to annoy you, to embarrass, or to make you feel oppressed during deposition. So if you're feeling stress mounting during the course of a deposition and you feel that the other party is attempting to embarrass you, and I'll give you some examples as to how embarrassment can play out in the deposition. But if you feel that you're being oppressed, embarrassed, or you're just annoyed, you can raise these words in your responses to the deposer to let the deposer know that they need to back off, and to let them know that you're aware of this Civil Code of Procedure that allows you to move for a protective order if you feel uncomfortable at any time during the deposition. So if one or more of the parties ask you a question that you're not comfortable with, and you may simply respond with, well, Mr. Smith, I'm not very comfortable with that question, and it seems that the purpose of that question is to annoy or embarrass me, and I want you to know that I'm not going to stand for any such line of questioning. And this puts the party on notice that you won't stand for any questions that are unrelated to the dispute at issue, which has raised the need for the deposition. Okay? And I'll give you more examples of that as we go. The code says that the protective order may include a ruling that the deposition not be taken at all. For example, that the deposition be taken at a different time, that a video recording of the deposition of a treating or consulting physician be postponed, or it may include an order that the deponent's testimony be taken by written instead of oral examination. And this is how you can get out of a very stressful environment if you don't feel comfortable in that environment. you can move for a protective order and have yourself removed from deposition and simply provide your testimony by way of a supplemental written report instead of oral examination. Okay, let's take a look at some other applicable sections from this Code of Civil Procedure. Other options or directions involved with the protective order include that the testimony be recorded in a manner different from that specified in the deposition notice. And numbers 9 and 10, this is important for us as qualified medical evaluators here. Number 9, that certain matters not be inquired into, and 10, that the scope of the examination be limited to certain matters. Now this is important for you as a qualified medical evaluator, and this is what will allow you to exert some control over the deposition and exert some control as to the types of questions that the parties can ask you at deposition. Now, the purpose of deposition is to provide testimony that will assist in the resolution of the case. So all line of questioning should be directly related to issues involved with resolution of the case. If one or more of the parties attempts to delve into matters associated with any other issues outside of that, you can feel comfortable in knowing that you have the power to limit the scope of the examination. You have the power to determine what matters can be inquired into and what matters cannot be inquired into. And many qualified medical evaluators tell me that sometimes at deposition, one or more of the parties asks sensitive questions about the nature of their clinical practice, ask sensitive questions about the status of their licensure and whether or not they've had any licensing suspensions or revocations or any disciplinary matters that are not related to the issue in dispute of the workers' compensation evaluation that you're involved in. So if at any time you feel that the parties are delving into questions or lines of questioning that are unrelated to the issue at hand, you can simply direct the parties back to the issue at hand, and you may use phraseology as follows. Say, for example, one of the parties asked you, what types of conditions do you take care of in your clinical practice? You may simply say, well, Mr. Smith, I don't see how that's relevant to the discussion at hand. What questions do you have about Mrs. Smith? Could you please limit your cross-examination to issues related to Mrs. Smith's case? Or sometimes an attorney will ask questions about, have you ever had your license suspended, revoked, or have you ever been under disciplinary status? And you may simply respond to that by saying, well, that is not relevant to our current discussion related to Mrs. Jones. Could you please not inquire into matters unrelated to Mrs. Jones' evaluation with me as the qualified medical evaluator? And this is where you can protect yourself here from inquiries that are not related to the resolution of the disputed issue related to Mrs. Jones. Okay, so this will allow you to relax and know that you are protected in those cases where the line of questioning gets unreasonable and out of hand. Finally, that designated persons other than the parties to the action and their officers and counsel be excluded from attending the deposition, and this protects you from having, spouses of examinees attend the deposition, for example. And then finally, that the examination of the deponent, which is you, be terminated, and if the order terminates the examination, then you can be relieved that you will not have to attend deposition related to this matter again, except on order of the court. So in terms of being comfortable at deposition, and as the lines of questionings get deeper and deeper, it's important for you to distinguish between those questions that are relevant to the resolution of the disputed issue and those questions that are not relevant to the resolution of the disputed issue, and to continue working with the parties to resolve disputed issues. but discontinue all discussion whatsoever about issues that are not relevant. Not relevant, because issues that are not relevant to the determination of the disputed issue are simply issues being raised to to harass and to annoy you and to perhaps embarrass you, which is, according to this particular civil code of procedure, is bad form and is not allowed. So you as the deponent are protected. So I share this with you to give you a measure of protection for your next deposition. Okay, so now let's continue along with the line of questioning related to some of the types of questions you can expect the parties to continue with in uncovering some of the medical legal disputes involved with your particular reporting. What are some of those other questions that you can anticipate in your very next deposition? I wondered this myself, and I speculated, and I pondered on this for a long time, and then I had an idea. I had an idea to take my last 10 deposition transcripts, and I want to encourage you to save every single one of your deposition transcripts and read those deposition transcripts periodically to learn from those deposition transcripts. And always ask yourself, what is the philosophy behind the question that's being asked of you by either the applicant attorney or the defense attorney? So I took my last 10 deposition transcripts and I extracted from the deposition transcripts every question that was posed to me. And I organized the questions by whether or not the question was posed to me by the applicant attorney or whether it was posed to me by the defense attorney. And I took a look at all of those questions and I organized the questions by categories. And I have that for you right here. These are all the questions asked of me in my last 10 depositions. And this is a 23-page document, double-sided. And the major categories of questions that I was able to elucidate from these deposition transcripts had to do with introductory questions, and I'll share a couple of those with you, familiarity and preparation questions, questions that attempt to ascertain your experience as a qualified medical evaluator, and also your experience in deposition, and then questions regarding the medical legal issues involved with the case, such as causation, such as mechanism of injury, such as the permanent impairment rating, such as questions that get you as the qualified medical evaluator to either admit or to deny the need for an additional QME in another specialty, and then some questions related to QME process and procedure. So I'll just share with you a couple of questions from some of these categories, not all of them and not from all of the categories, but just to share with you some questions that come from each of these major topic headings. And I'm sure you'll recognize these questions as operative in your own depositions as well, if you would review your recent deposition transcripts. Okay, so for example, some introductory questions would include, good afternoon, doctor. Can you state your full name for the record? Okay, doctor, have you had your deposition taken before? This is an introductory sort of rapport building and get the process going type of question that is not related in any way to the medical legal issues involved in the case. Doctor, have you had your deposition taken before? Have you ever been deposed before besides this case? Doctor, you took a thorough history from the examinee during your evaluation, correct? Isn't that correct? Or is that correct? Okay. And so these are some various types of introductory questions that are designed to get familiar with you and to get the ball rolling. Now the next category of questions has to do with familiarity and preparation questions. And some of those questions could include, doctor, you served as the panel QME case for Mr. Jones. Is that correct? And that's correct. You evaluated him on one occasion. Is that correct? And the parties are getting familiar with the details of the case and bringing the details of the case out into the open and out onto the table so that the discussion can begin. As we sit here today, tell me if you recognize this question. Do you have any independent recollection of Mr. Jones? Did you review any documents or chart notes in preparation for your deposition here today? And this is a familiarity and a preparation question. They need to know how you prepared and what you reviewed for the deposition so that you can all be on the same page. And therefore, if there's something that is a document that you did not review, the parties will know that this will be an opportunity that they can raise awareness of that document, knowing that you did not cite this document as one of the documents that you reviewed in preparation for the deposition. Let's go on to a couple other types of questions. How about ascertain experience? This is where they ascertain your experience as a qualified medical evaluator. Doctor, when did you start doing QME work? How many QME evaluations have you done this year? How many have you done lifetime? How many QME locations do you have? How many QMEs do you do in a year? How many do you do in a month? How many times have you been deposed before? They're ascertaining your experience as a qualified medical evaluator to likely get a sense as to how familiar you are with correct legal principles and how familiar you are with the various aspects of the QME evaluation, including your familiarity with the AMA guides. Okay? And many, many other questions relating to causation, relating to the mechanism of injury. Of course, you're going to get questions related to your permanent impairment rating. Let's talk about a couple mechanism of injury questions, and then we will conclude today's program. An examinee who fell. This is an examinee who fell and who was caught while falling by a co-worker. Do you know if there's a size discrepancy, a size or a weight discrepancy between my client and his co-worker who caught him while falling? So this is a question regarding the mechanism of injury. Do you know how long my client laid on the floor after striking the floor? Do you know how long he laid on the floor? Do you know whether he struck the left side of his body, whether he struck the right side of his body? Did he strike his hip? Did he strike his shoulder? When he was lying on the ground, was he lying on any body part? And all these questions related to the mechanism of injury. So doctors, I hope this helps you. You know, depositions can be a great learning experience for you and help you learn the case from the perspective of the other parties. I always enjoy depositions because we as qualified medical evaluators, we're familiar with the case from our perspective. Well, the other parties to the case have their perspective as well. And it's only in deposition that we learn what the other perspectives of the parties are. And if we can learn some of the perspectives of the other parties, it helps us better prepare our own arguments in the future so that we can anticipate the needs and the perspectives of the other parties, and we can address those in advance. So doctors, I hope this helps you. And I want to conclude today's program by just summarizing the whole philosophy of the QME Forensic Super Sleuth. And that has to do with you becoming the very best qualified medical evaluator of which you're capable. And in order to do that, you need to continue to expand your experience and continue to expand your learning and your knowledge of the issues that govern the cases that we as qualified medical evaluators are called upon to evaluate. We think that when we evaluate an injured worker, we think that our agenda and our procedures and our intentions are the only procedures and the only agendas that surround the particular case or claim, and that's simply not true. And the more that you can understand the needs and perspectives of the other parties, which they don't tell us, they don't tell us this, but the better you can understand the needs and perspectives of the parties, the better qualified medical evaluator you can become, because you'll have a better ability to address those needs, to resolve those issues, to handle those disputes by knowing what are the issues around the disputes that need to be resolved, and knowing how those particular issues are resolved in the system can allow you to actually help move cases forward in the system and prevent the logjam and help alleviate the logjam that has currently got cases backlogged in the system into the months and even years. So this is all about how you as a qualified medical evaluator can become the best medical evaluator possible by knowing that which they don't tell us. Okay? So I want to thank you for taking the time to join me on this discussion, and I also want to take a moment here to sincerely appreciate you for your commitment and your dedication to excellence as a qualified medical evaluator. For now, this is Dr. Perry Carpenter. I'm looking forward to being with you on future presentations, and for now I'm wishing you the best of success.